Adam Willoughby, and Liz has kindly invited me along today to talk to you about stress in the workplace and disability discrimination, if I can say it right. Just to introduce myself, I'm a barrister from Broadway House Chambers in Leeds and Bradford, and I regularly am instructed to deal with claims against employers, usually for discrimination and some other uh, breaches of duty of care and that sort of thing. I appear for employees and employers. That gives me a relatively good overview of both sides' arguments that are regularly run. And so hopefully today I can give you some tips from an employer perspective on how to deal with claims arising from stress in the workplace, and sometimes that stress can lead to individuals, to employees having a disability that normally manifests itself by way of depression and or anxiety. So hopefully I can give you some useful tips today, and as we go along, if you have any questions, pop them in the box and I'll deal with them if I can, but we'll certainly have time at the end to deal with your queries. Happily, it is National Stress Awareness Day today, and what I'm going to ask Liz to do now is to put a link to the International Stress Management Association website. What they do is offer some free guides. At the moment, they have a free wellbeing guide on their website, and that's a really good website for all sorts of different tools, and you can pick certain tips up from there. So I'd encourage you to go and have a look at their website and see what you can get from it. Moving on to the next slide, just to tell you a bit more about where I come from and my chambers specifically. We are, as I said, situated in Leeds and Bradford. We like to think of ourselves as doing things slightly different. We're quite a modern chambers. We have a modern approach to things. And gone are the days where you have dusty corridors and dusty law books. We like to think we're quite modern and with it, so to speak. You'll see on the slide there some key cases we've been in. Myself, I've been in a case called G4S versus Jones that went to the EAT, and you'll see some quite famous cases: Vento, Khan, Hershaw, Redcar, all of those sorts of cases. Happily, we've had barristers appear in those cases. So we like to think of ourselves as a good set, and we're certainly available for instructions and offering advice, and certainly appearing on behalf of employers in tribunals, and our website's at the bottom of that slide. But shameless plug over, and moving on to what we're going to consider today. First of all, we'll have a look at what stress is, and often people think stress itself is a medical condition, and it's not. We'll have a look at what stress is and how it may arise. More importantly, we'll look at the effects of stress on employers, and specifically the duties of an employer when dealing with employees who have become stressed and who have developed certain symptoms. We'll then look at stress as it becomes a disability, and when the symptoms become a disability, and what, as employers, you are under a duty to do then. Specifically, we'll look at reasonable adjustments and finally unfair dismissal. And throughout, I'll hopefully give you some practical advice and HR, some tips for you HR personnel who are listening today. Moving on to the next slide, we'll first of all identify stress. Well, the Health and Safety Executive have identified stress as an adverse reaction that people have to excessive pressures or other types of demand placed on them. Similarly, the ACAS guidance identifies a difference between pressure creating a buzz, which is often a motivating factor, and the negative experience which can occur when this pressure becomes excessive and the individual is unable to cope. Now, what both identifications, if I can call them that, do there is identify this notion of excessive pressure. We all, to an extent, thrive under pressure. It's the nature of our job as HR personnel and lawyers dealing with often difficult employees. But it's when that stress, or when that pressure becomes overbearing and there is an inability to cope, that's when you start to have employees suffering with stress. The next slide is quite interesting because what that says is stress is not an illness, but rather it's a psychological, the psychological impact of stress can lead to problems with mental health. Often that manifests itself as anxiety and depression, but sometimes it can manifest itself as physical problems such as heart disease, back pain, and stomach upsets. What used to be the case is employees would go to their doctor, describe symptoms of stress, and you would see on the sick note stomach upset or migraine or something like that. Now there's the stigma surrounding stress and mental health has declined to a certain extent. And so what you often see now on fit notes, as they're called now, is stress. That's not a medical definition. That's not a medical illness, but rather it's a description, if you like, of a range of medical ailments. And as we've said before, it's a reaction, if you like, to excessive pressures. So that's something to be alive to. As HR support and as HR personnel, you should always be informing your managers to look out for when there is potentially excessive pressures, and also look out for when your employees are starting to display psychological or physical problems, because as I've said, and I hope you've got the point now, stress doesn't necessarily come with sort of a red light flashing on an employee's head. You have to look out for the signs of stress, and that's really important. The next slide just identifies how stress may arise. Obviously, as HR personnel, we're not privy to the employee's personal life. Sometimes they tell us about certain things, such as, I'm getting a divorce, and so we should be alive then to the fact that they may be suffering with stress or having a certain emotional reaction. But what we should be alive to, and there's a reasonable assumption that employers are on notice of this sort of issue, are work-related pressures and work-related stress. There is, I would say, an assumption in trials that employers are alive to the fact that because they've increased the workload of an employee, that may be putting an excessive pressure on them, and they should then look at the ability of that employee to cope. But in terms of how stress may arise, it's often a combination of employees' personal traits and personal lives combined with the work-related pressures. So that's something to be, as I said, alive to as HR personnel, and that's certainly something managers should be alive to when delegating responsibilities and tasks to employees. Just moving on, why do we need to worry about this? Well, you can see the figures on the slide there. The work-related stress costs society an awful lot of money. We don't have recent figures, but in 1995 to 1996, it was upwards of £3.7 billion. We now have recent figures on the ACAS website stating that stress is now the most common reason for employee absence, costing UK employers an estimated £1.24 billion a year. You need to be aware of stress-related issues clearly from an economic perspective, but also because of the legal implications and potential legal liabilities that you can find yourselves having to defend in a tribunal. Just moving on from that, onto the next slide, you'll see also that modern day working lives, we do to some extent shamelessly have a more for less culture. People are working longer hours, there's often increased pressure to meet deadlines. And there's a rising awareness of stress issues, and as I said earlier, mental health is becoming much less stigmatized. Now, it may be that people have always suffered with stress-related illnesses. That's probably true, but they've never been identified as such. Now that stigma is decreasing, people are much more willing to go to their GP and say, hang on, I'm really stressed at work, I can't cope. And that's where I think we've seen an increase in stress-related illnesses, and we now know that stress is the biggest factor, or the biggest reason, if you like, for stress-related, for absence. Just out of interest, I'm going to do a poll. How many of you think a risk assessment is worthwhile in identifying stress in employees? This is before we move on to the legal implications. But how many of you think doing risk assessments is a worthwhile exercise, if you like? Okay, that's really interesting. So we've got 4 of you thinking, 5 of you thinking it's not worthwhile. We've got 14 thinking it is. So a majority of you think it is worthwhile. But we've got a significant number, 6 now, saying it's not. Okay, 7 of you. That's interesting. That's interesting from my point of view.
No, I don't think it is working.
So both really. So Mandy's asked, do I mean a risk assessment for the individual or the role? I suppose it's both really. So you're looking at workplace risks. That's how I'm going to phrase the question. So you're identifying both what the role is and the suitability of people to do that role. Okay, so we've got the results there. So 8 of you think no, 15, 16 now of you think yes. We'll move on to the next slide, and you'll see the answer to that. There's actually a specific duty to carry out a workplace risk assessment to identify potential risks. And in my experience, these regulations and that specific provision has been extended. And Mandy, this is where your question is really quite an important one, because some lawyers will extend that to say, well, it's just simply the role that we need to risk assess, and most people are fine in that role. They're fine doing that amount of work. Other barristers in trials will, for employees, will try and say, well, actually, you need to do an individual risk assessment of that particular employee, look at their vulnerabilities, look at their past work record, and see whether whether there's a risk for them doing that role. So I suppose what you should take from that is those regulations are flexible. They can be applied in either way. On behalf of claimants, it can be, well, actually, you need to do a far more detailed risk assessment than an employer would say, where an employer would say, well, actually, you just need to look at the role. My advice is that you should really carry out the risk assessment looking at the role itself, so what does the role demand, and then assess the suitability of certain employees to do that role. So if you have an employee who has previously been off work with various stress-related issues, and those issues have related to the inability to take a certain amount of phone calls, for example, that risk assessment should really involve looking and sort of, does that employee match up with that role? So that, in my view, is what those regulations require you to do. Equally, the Health and Safety at Work Act puts a duty, if you like, on employers to ensure, as far as reasonably practicable, their workplaces are safe and healthy. So stress, mental illness would fall into the definition of, or fall under the umbrella of, is the workplace safe and healthy? And if you're not constantly reviewing whether or not certain employees are fit to do a certain role, you're going to come unstuck at some point, in my view, because you need to take measures to control any risks. So if, for example, an individual is not meeting their deadlines of producing certain documents at certain times, for example, then you need to take measures to control any risk. Those risks may be that they're simply not coping, and they're starting to look very sort of ill and all that sort of thing. Mandy, I'm just going to read your question. How would you suggest this is managed without health assessments at the recruitment stage? Well, it's very difficult, and I know by Section 60, I think it is, of the Equality Act, you're not allowed to ask them about their health except in certain circumstances. Really, this is when they're in the role. So you've got your employee. If there's nothing to make you alive to the fact that they may be sort of under any disabilities or anything like that, or have any health ailments which are going to lead to them having certain difficulties, I appreciate it's very difficult to sort of prevent this happening at an early stage. I suppose what you need to do is look at their employment history, look at what they've done in the past. If you have someone who's not used to being able to, I don't know, field 100 calls a day or something like that, then you're probably going to have difficulty in matching them up to that particular role. When an employee is in employment now, you need to look at what their best assets are really, and look at what they've done in the past and what the role requires. Vicky, that's interesting. The NHS, there is a pre-employment health screening as part of our national standards around recruitment. I don't know to what extent that's compliant with Section 60. I'd imagine it is. I'd imagine you've taken advice on that. But certainly you can look at what their abilities are without going into their health. It's really looking at what they can do and what the role requires. I don't think that falls foul necessarily of this inability or this preclusion, if you like, of looking at their health record. It's what they can do, what they're capable of doing, and that's really what the regulations in this Act requires. Just moving on, I'll also make you aware of Protection from Harassment Act 1997. It's very difficult, in my view, for employees to succeed against their employer under the Protection from Harassment Act. But if someone is stressed, it can be that the constant application of pressure and increase of workload can, if they meet those bullet points, I'm not going to read them all out, can potentially amount to harassment. So that's something to be aware of. It's rare, but I add it for completeness. In addition, just moving on, you also have, as employers, a common law duty. You owe a duty of care to your employee to essentially not exert so much pressure on them that they become stressed and ill. It has to be foreseeable. So first of all, an employee must prove breach. You breached the duty of care towards me because you put excessive pressures on me. But the court would have to look at what did the employer know or ought to have known about the pressures on the individual employee at the time. So what they would do is, was it foreseeable that us increasing their workload by 40% would add to their stress levels? I've put a case there. It's worth making a note of that and looking at that in your own time. But Barber versus Somerset County Council, that was a teacher, and he was telling management, I'm having difficulty coping. The management didn't do anything. And what the court held is, well, it was foreseeable that the way in which you changed his role would increase his stress levels. And you owed a duty of care. You didn't act on that, but your managers were aware, and thus you breached your duty of care. It was foreseeable, and the standard of care is that you should have essentially looked after him in this role. And I think there was a discussion in that case of employing a temporary teacher to take over some of his duties would be proportionate. Would be a proportionate step to maintain and look after a long-term employee. So that's as well as the regulations, the Act that we've looked at. the Harassment Act as well, you have a common law duty. I'm just going to read, Catherine, your question. Where would we stand if the employee was specifically employed for telephone work, but now stating they can no longer carry out this role? Um, well, I think the best practice in that case would be to explore why. Uh, if it's the case that they simply can't cope, you need to explore why that is. Is there an underlying mental illness or something like that? Um, if it's simply that it, the workload is excessive, or I'm unable to cope because I consider it excessive, in those circumstances, having done your risk assessment, so you've looked at the individual, you've looked at the post, they've previously done it but now they can't, you either go down two routes in my view. You either move them into a different role and try to help them in put them into that alternative role, and that role should suit their abilities, or you go down a capability route. Are they capable to do the work? Barbara, I'm just looking at your question as well. I agree, increasingly more people are getting signed off with stress when they're in a disciplinary process. Um, what you would do then, I suppose, uh, if they are in a disciplinary process and they are um, stressed, if they're suspended, I suppose it's the disciplinary process itself which is causing the stress. You have to follow your own policies, and so I can't say to you, well, um, stop everything and don't apply the policies because they're stressed. I don't think that's always the right thing to do. If they are continuing in their work, and it's the work and the combination of the work and the disciplinary process which is causing their stress, then in those circumstances, you would probably look at reducing their workload so they could deal with the disciplinary process, or suspending them if you thought that was the right thing to do because you needed to investigate and you couldn't whilst they were in their role. It's very, very difficult. What I would do is get an occupational health assessment to see why they're stressed. I don't think it's appropriate to completely disapply disciplinary proceedings when an individual's stressed, because it is a stressful thing to do, to go through, sorry. If they're in work, you may look at putting certain procedures in place, or making certain, taking certain steps to alleviate their stress whilst they're going through the procedure. But it's very difficult because the disciplinary processes are inherently stressful, and often, I agree, often they are uh, signed off, and they very frequently, in my experience, ask for the disciplinary process to stop because they're stressed, and that simply is not an appropriate step to take, in my view. Um, just moving on, I want to touch on disability discrimination, because stress, as I said earlier, can manifest itself as several illnesses, and it's usually depression in my experience. Usually an individual will say, I'm so stressed it's become a mental health issue, and I'm depressed. You have to be careful, and this is, if you take anything away from today, take this. If an individual is stressed, it may lead to them having depression or anxiety, and that may lead to them being a disabled person within the meaning of the Equality Act. That is a vital thing for you to be alive to, because if they are disabled, then there is a new layer under the Equality Act of duties on an employer. Now, it's not it's not that easy. That's probably quite loose language, but there's a specific test to identify whether or not an individual is disabled. It's under the Equality Act 2010, and you can see the 4 steps there. Now, those 4 steps, I could give a webinar just on those themselves. But those 4 steps are what the employee would have to satisfy for the tribunal to say, well, yes, you are a disabled person. Once they've identified that individual as disabled, you then have, as I said, a new layer of protection for the employee. In order to identify whether an individual is disabled, you need to ask yourself not only those 4 questions, but the questions I put on the slide there. How is the stress manifesting itself? How severe is it? And are they still able to function? Often you get employees who are still in the role, they're stressed, but they're carrying on, and they've developed depression. It may be that they can still do their job, but it may be that outside of work, they're having difficulty doing certain things, such as going shopping, and the tribunal would look at all of those factors to assess whether or not they're disabled. But certainly from an employer's perspective, if you can start asking yourself those questions when you suspect an individual is stressed from an early stage, you can then start to identify whether or not you think there is a risk the individual might be disabled. Occupational health referral is a must in my view, but don't rely just on the findings in that referral. You must always make your own assessment of whether the individual is, for example, depressed, or whether the individual is having certain difficulties functioning. You can also consider a psychological assessment to see whether or not a psychologist would think, whether a psychologist would think there are certain aspects of their behavior, if you like, which could lead to a finding in a tribunal that the individual is disabled because, for example, they are depressed. Moving on to the next slide, you'll see there the types of protection, or the types of discrimination, if you like, an individual can experience. They can either be directly discriminated against or indirectly discriminated against. But there's always a duty to make reasonable adjustments if, and I'll come on in more detail to reasonable adjustments in a moment, but if an individual is disabled and, for example, there is a certain physical barrier at work, for example, or there is a requirement for them to do a certain thing which, because of their disability, they're unable to do, then there is as an employer, there is a duty on you to try as far as is practicable to remove that particular barrier. But also, if they are disabled, then they have a protection from harassment and from victimization. So those are the 5 layers of protection, if you like, for a disabled person. So we've gone from identifying stress to an awareness that stress can be stress can lead on, if you like, or be a sign for a disability such as depression. You've identified as an employer what potentially those aspects are of the behaviour, of the characteristics of the individual, which can lead to a finding of disability. And then once you identify that they are potentially disabled, this is what you are precluded from doing, or this is what you must not do. You mustn't victimize them. You mustn't put in place a policy that puts them at a disadvantage because of their disability and that sort of thing. Just a quick poll whilst we're on this slide. Do you think an employee, if they are unaware the employee is disabled? Be interesting to see your answers there. Okay, that's interesting. So we've got 8 of you at the moment thinking yes.
Not a very well worded.
So the majority of you think yes, and moving on to the next slide, that's interesting. You're absolutely right.
Oh.
A key warning is an employer can discriminate against an employee even if it's unaware of the disability. That commonly arises in indirect discrimination. For example, someone is stressed and they have certain muscle aches, and that can be a symptom leading on from stress.
Okay.
They have certain muscle aches. They work on a line. They work on a production line, and there is a policy put in place that you must produce 100 units per minute, that sort of thing. If that individual, because of their muscle aches, is unable to produce 100 units a minute off this production line, then that could, because of their disability, put them at a disadvantage, and they could start then facing disciplinary procedures because they've not been doing their job properly. That would be a case of, just thinking out loud, of indirect discrimination. You may not know, you may not be aware to the fact that they have these muscle aches because they wanted to keep it to themselves, because they feel silly, for example, that they've got the muscle aches from stress. But it's important, it's really important to be alive to the fact that employees could be disabled. And that's why I said earlier, you need to look at the severity of what they're complaining about, if they are complaining. Look at if there's been a sudden drop in their workload and they're looking, really fatigued or what have you. Start looking at the severity of the drop in their workload, and could this be a situation in which they're stressed, which has led to a physical impairment, and that in itself could be lead on to a finding that they're disabled, and therefore you have to take into account that sort of thing when you apply the policy. You see on the screen there reasonable adjustments. This is just moving on. I want to touch on reasonable adjustments briefly because this is one of the most common complaints, if you like, of individuals who have suffered stress. They have said that they are feeling down and that they are in despair and can't face the prospect of coming back to work. Now, what you have there is Section 20 of the Equality Act 2010. That provides the duty to make reasonable adjustments, and that comprises of 3 requirements, and you'll see the requirements set out if you have a look at the Act, Sections 20, subsection 3, 4, and 5, and we're going to look at those now. So you'll see there, I'm not going to read all that to you, but you'll see 3, 4, and 5. There is a requirement where you have, for example, provision, criterion, or practice, and we can do a whole other webinar on that, and we will in the future. But where you have a practice, for example, of you must make 10 phone calls a day to source work, that individual is depressed and they have become really shy at talking to people, for example, and that's because they've become stressed and, as I've said, that they're depressed. If you have that policy and they come back to work, they are going to be at a substantial disadvantage in relation to making those calls than persons who are not disabled, who don't have that shyness because of the depression. In those circumstances, you are to take such reasonable steps to avoid the disadvantage. So you don't have to absolutely avoid the disadvantage, but do take reasonable steps. If you don't comply with those requirements to essentially help the employee back to work by removing obstacles, that's what this really boils down to, then there is a failure to comply with the duty to make reasonable adjustments. I'll give you an example of a recent case I had. The individual was stressed and as a result would have periods of incontinence. Now, the employer said, we'll do you a phased return to work, but it's going to be at a smaller site. But that smaller site was full of men, and this claimant was a lady. She said, well, I feel really uncomfortable. If I have an episode in front of these men, it's going to be very, very embarrassing. And they said, well, look, it's like your lumpet. We've said we'll move you to a smaller site to take into account that you're having these difficulties. We can't help it that it's men. And the tribunal found that the employer actually did all it could in the circumstances, and operationally it couldn't have put her anywhere else. It was either the large site or the site with men. But thinking about that, it may have been that they could have put her, moved her desk nearer to a toilet or an exit point or something like that, or given her her own private office. So those are the sorts of steps which you should be looking at to make reasonable adjustments. And you'll see on the next slide, it's all about reasonableness. The duty to make adjustments is, and it's a matter of policy to help employees remaining in employment and have access to their employment. So this whole area of reasonable adjustment is getting the employee back to work. And there is at Schedule 8 of the Equality Act, it's worth having a look at, this exception that an employer is not under a duty to make reasonable adjustments if they don't know or could reasonably be expected to know that a disabled person has a disability and is likely to be placed at that disadvantage. Now, what's really key there is could not reasonably be expected to know. As employers, often it's the case that you are expected to know if an employee has exhibited certain behaviours, or if you have recently increased the workload and they are missing their targets, for example. That may be a sign. And as I said earlier, that teacher who had spoken to the managers and said, look, I'm really not happy because I'm having difficulties here. In that particular case, the employer could reasonably be expected to know that they were having certain difficulties. So it's an exception, but it's not an easy one necessarily to get out of. Moving on, if someone has been discriminated against, there's no automatic unfair dismissal by reason, if by reason of their disability they've been dismissed, but it's likely to be unfair. If you treat someone badly when they are under such a disability, then you can have claims of constructive dismissal, and you may, in circumstances where an individual is not, as you see it, or as you may see it, pulling their weight because they've got certain physical symptoms which you may not be aware of, you may want to take them down the capability route. But in that case, you need to be fully aware of the reasons why. You need to fully investigate. This whole sort of talk and all the aspects of the talk can also lead, so all those aspects of stress and disability I've been talking about can also lead to employers taking employees down the conduct and excessive absenteeism route. If you have turned a blind eye or ignored or just not been as careful as you should in identifying the fact that someone may be stressed or depressed, then you may find yourselves in troubled waters if you're dismissing someone for excessive absenteeism. If they turn around after the event and say, well, actually, I was stressed because of what the amount of work you put me under, you didn't risk assess it, you didn't exercise your duty of care, and you didn't make any reasonable adjustments, and here's my ET1, I'm claiming unfair dismissal. So you need to be alive to these issues from an early stage to avoid claims of unfair dismissal. As HR officers, you'll know this already, but do have your paper trail. It's so important to have your paper trail and look at what you've asked employees. If you've interviewed them, have your paper trail of what sort of issues they've raised. Have they raised issues of excessive workload? Have they complained that they're feeling tired, or they've got a stomach upset because they may have some irritable bowels? That may be a sign of stress. How many of you, just if you can type in the chat box, have a stress at work policy, or have been involved in drafting a stress at work policy? It'd be really interesting to see. So quite a few of you have those policies. It's really good. Well-being at work, yeah, that's really good. They're called different things, but stress and well-being at work policies, they're really good to have, because not only does it give you a sort of a guide as HR officers and as managers to conduct in these sorts of the meetings and general management exercises with employees, but it also, if you ever get to the tribunal, and hopefully you won't, it's good to say to the tribunal, look, we have these policies, we're alive to these issues. So if you haven't got those policies, I would get them. Just out of interest as well, just as a final note, and hopefully you've picked up some useful tips throughout this, how many of you have dealt with stress in the workplace issues in the past 12 months, say?
Sorry, I wasn't paying attention. How many have dealt with stress in the workplace? Yeah. Oh gosh, yeah. Oh gosh,
yeah.
Yeah.
Lots of you. Okay, so drawing on that, And just ending on a bit of a Q&A session, if I may. Do, I've got a minute. I'll answer as many questions I can in a minute. Have any? Yeah, we'll do a live Q&A another time, as Liz has just said. But if any of you have specific questions in relation to those issues that you've had, do feel free to email me. My email address is there. Do feel free to drop me an email. If I've not been able to answer your question today, 'cause there's been a lot to get through, you'll see my email there. None of what I've said is legal advice. It's a general guidance drawing on my experiences, if you like. So it's not legal advice, but if any of you have queries of certain things I've spoken about, or if any of you want to send me the questions you've put in the chat box, which I've not been able to get to, do feel free to email me. I hope you found it useful. The key thing to take away is be alive to what your employees are going through. Engage with them, and make sure your managers are engaging with them all the time, and obviously keep a note of everything you've done. I think that's it. I think that's my time's up. I hope you found it useful. I'll pass you back over to Liz.
Thanks, Adam. Sorry it got so run away there on time. There's a lot to cover. There's so many good questions that came through within the content of that webinar. I am going to sort of run it off and sort of show through to Adam and see if there's something we can come back to you directly. Again, I think a Q&A session on this particular issue could be something that we may be looking at in the new year as well. So much appreciated. Thank you, Adam, and thank you everyone for all your comments and engagement there. Very, very useful indeed. And equally, if you do have a couple of minutes, I'd really appreciate your feedback as well in the Pay Compliment website. And we have been tweeting, and there's a lot of stuff going on Twitter. I was looking at it whilst we were on the webinar about National Stress Awareness Day. There's some really useful articles from ACAS, from the ISMA.org, all sorts of things. So please, I'd recommend you have a look there as well to sort of add another value to this particular webinar. And finally, next week we've got a practical approach to project management, and then the week after whistleblowing and steps to mitigate that as well. So I shall leave you all now, bang on time. Thank you ever so much everyone for joining us and for all the support and all your patience, and look forward to seeing you again. Adam's next event will be on the 24th of November, and we're going to be looking at the holiday pay and how we can push the boundaries on that one. So welcome to that one on the 24th. Thank you very much, everyone.